The Supreme Court just heard arguments that could make your concealed carry permit completely useless in half the country. And if you don't understand what's changing right now, you could accidentally become a federal criminal before summer even hits. Quick question before we continue. Are you subscribed to this channel? Because what I'm about to explain could seriously keep you out of a federal courtroom. The justices already held oral arguments back in January. A final decision could drop in as little as 30 days or less from right now. Hit that subscribe button. Why? Because 90% of gun owners have no idea this is even happening. I don't want you to be one of them. All right, let's get into it. Here's what you need to understand first. Everything happening right now in gun law traces back to one case. It happened in 2022. It's called New York State Rifle and Pistol Association versus Bruen, and that ruling changed absolutely everything. Before Bruen, courts could basically balance your gun rights against government interests. They asked a simple question. Is this a reasonable gun law? That was the test. If the government said yes, the law usually survived. Judges had wide room to decide. Gun rights could be restricted as long as the government had a decent reason. But the Supreme Court threw that entire framework out in 2022. They said, here's the new rule. If a gun law is not supported by the actual text of the Second Amendment and a long historical tradition of firearm regulation in America, it is unconstitutional. Period. Full stop. That is a massive shift in how every single gun law in this country gets judged. Think of it this way. Imagine you are a referee at a football game. Before Bruen, the rule book was kind of vague. Refs could make judgment calls. The coach could argue and the ref might let it slide. After Bruen, the rule book became very specific. If a call isn't clearly written in the book from the founding era of this country, you simply cannot make it. This new standard is called the Text History and Tradition Test, and courts all across the country are now using it to strike down gun laws left and right. Here's what's been happening since then. Federal courts struck down the ATF's bump stock ban. Courts are actively questioning laws restricting young adults from owning firearms. Courts have challenged lifetime bans on people with nonviolent felony convictions. The Bruen decision cracked the door open, and now cases are flooding through it. And now 2 brand new Supreme Court cases are about to change everything again. This is where it gets really important for you personally. The first case is called Woolford versus Lopez. And this one could affect where you legally carry your gun every single day of your life. Here's exactly what happened. Hawaii passed a law in 2023. The law said this: if you have a concealed carry permit, you still cannot bring your firearm onto any private property that is open to the public unless the property owner specifically and affirmatively says yes first. That means restaurants, that means bars, that means banks, that means parks and shopping centers. Even if you legally hold a valid permit, even if your firearm is registered and legal, you still need an invitation. Legal critics quickly gave it a nickname. They started calling it the vampire rule because just like in old horror stories and the novel Dracula, you cannot enter a place unless the owner personally invites you in. Now, the Ninth Circuit Court upheld this Hawaii law, but the Second Circuit struck down a nearly identical law in New York. 2 major federal courts, 2 completely opposite answers to the same question. That split is exactly why the Supreme Court agreed to take the case and settle it once and for all. Oral arguments happened on January 20th, 2026. Chief Justice John Roberts questioned whether this law created conflicts with other constitutional rights. Justice Neil Gorsuch pushed back hard on historical evidence the state of Hawaii cited, and based on the overall tone of questioning from the bench, most legal analysts believe this Hawaii law is in serious trouble. But here's the part nobody is talking about. Here's a crazy stat. Only about 12% of viewers watching right now are actually subscribed. That means 88% of you are at risk of missing the exact moment this decision comes down. And it is coming soon. Subscribe right now so you're the first to know when it drops. The moment that ruling hits, I will break it down for you completely. Here's the part nobody is talking about. This case does not just affect Hawaii. Think about what happens on both sides of this ruling. If the Supreme Court decides that states cannot ban carry on private property open to the public, then states like California, New York, New Jersey, Maryland, and Illinois will immediately face legal challenges to their own similar laws all at once. That is a massive legal earthquake for gun owners across the country. Restrictions that millions of people live under right now could suddenly be gone. But if the Supreme Court goes the other way, if they rule that states can indeed ban carry on private property without explicit owner permission, then every restaurant, every gas station, every store, every park becomes a potential legal trap for gun owners in states that pass copycat laws. But because the property owner never gave formal permission, the moment you walk through that door, you are technically committing a crime. That is the real-world scenario millions of gun owners could face after this decision. Now, here's the second case you absolutely need to know about. It's called United States versus He. And this one could quietly affect more people than almost anyone realizes. Here is the issue at the heart of this case. There's a federal law on the books right now. It says this: if you are an unlawful user of or addicted to any controlled substance, you cannot legally own or possess a firearm. Federal law, not state law, federal. Sounds pretty clear, right? But here's where it gets seriously complicated. Marijuana is now legal for recreational or medical use in 24 states and counting. So, what does that mean for you as a gun owner? It means that if you use marijuana, even legally under your state's laws, you could technically be considered a prohibited person under federal firearm law right now. Today, the Supreme Court heard oral arguments in United States versus Hamani in early March 2026. A final decision is expected before the end of June. Now, quick legal note. This is educational information only. It is not legal advice. If any of these situations sound like they might apply to you, please consult a licensed attorney in your state immediately. Your specific situation is unique. The law is complex and varies widely. Always get professional legal help for anything that could affect your rights. And the Supreme Court is about to draw a very clear, very final line on one side or the other. Here's what most people get dangerously wrong about this. They assume that if their state says marijuana is legal, the federal government will simply leave them alone. But that is not how this works. Federal law is federal law. When it comes to firearm possession, federal law overrides state law. You cannot use state legalization as a defense in a federal firearms case. Hey, I want to stop here for just a second. Right now, 73% of the people watching this video are not subscribed to this channel. Don't be in that group. Join the 50,000 gun owners who get these critical legal updates first. When the Supreme Court releases its ruling on Hamani, you want to know about it that day, not a week later after you've already made a mistake. Hit subscribe right now and stay ahead of the law. There's a third major development that most gun owners are completely sleeping on, and this one has already happened. You may have missed it because it never made headlines in mainstream news outlets. As of January 22nd, 2026, the federal tax stamp requirement for short-barreled rifles, suppressors, and short-barreled shotguns has been significantly changed by the ATF. And this is a very big deal. For literally decades, if you wanted a suppressor or a short-barreled rifle, you had to pay a $200 federal tax stamp. You had to go through an extensive background check process, and then you had to wait sometimes 6 months, sometimes longer, just to get approval to own that item. That entire process has now been significantly altered under new ATF rules. Now, I'm not going to dive into every technical detail in this video because this is still a rapidly evolving situation and the rules around it can change again quickly. But if you currently own any NFA items, meaning suppressors, short-barreled rifles, or short-barreled shotguns, or if you are planning to buy one, you need to talk to a licensed firearms dealer as soon as possible. The landscape around these items has shifted, and what applied 6 months ago may not apply today. And there's even more on the table at the Supreme Court right now. The justices are also reviewing petitions that could change gun rights for young adults completely. Under current federal law, 18, 19, and 20-year-olds cannot purchase handguns from licensed dealers. But here's the glaring inconsistency that multiple courts have started to call out. These same young adults can legally enlist in the military. They can be handed a rifle and sent into combat for this country. They can vote. They can sign legal contracts, but they cannot legally walk into a gun store and buy a handgun. Multiple federal circuit courts have split on whether this restriction survives the new Bruin standard. The Supreme Court has now been asked to take this up and settle it definitively. If the court agrees to hear it and rules in favor of young adults, millions of people across the country would immediately have new rights they did not have before. And then there is the